Today I am going to talk about the very recent review of the Supreme Court judgment in the case of Canon India, wherein if I may state the issue in the brief, the issue was whether DRI, that is the Directorate of Revenue Intelligence, has the authority to issue so-called notice under Section 28 of the Customs Act for recovery of, say, duty short levied or not levied or short paid or erroneously refunded. And it was held by the Honorable Supreme Court that since DRI is to issue so-called notice under Section 28, therefore, the DRI is not a proper officer to issue so-called notice. Today, I am going to confine the discussion to the checkered history of this particular issue. Now, this particular issue, whether you see a customs officer of preventive or an officer of the revenue intelligence whose main you see function is to detect any evasion of the duty in the case of import, whether that particular officer, whether that officer has the authority to issue so-called notice. So you see it has a checkered history, as I stated, and I am going to confine myself today to discuss the statutory framework of the Customs Act with respect to the investigation and the detection of the short evasion and the history of this particular case leading to the judgment in the Canon India. I'm going to discuss the review in the next session. Because if I do the review also today, then it will become a very long session, which I don't intend to do. I just intend to do, you see, every Friday, a short 15-20 minute session to discuss any topical issue. So this is part of that endeavor to have a short discussion on any topical issue of topical interest. So let me tell you that under the Customs Act, under Section 4 of the Act, an officer is appointed as an officer of customs. Now, under Section 2, subsection 34, there is a definition of the proper officer. So the proper officer means when in relation to any function to be performed under this Act, the officer is a proper officer of custom who is assigned those functions by the board or the principal commissioner of customs or the commissioner of customs under Section 5. So every officer of customs is not a proper officer to exercise all the functions under the Customs Act. So that is the short and long of the definition of the proper officer. Means the proper, an officer may be an officer of customs. Say suppose an officer is appointed as an officer of customs under Section 4. Now, the task which he will do, the kind of functions which he will perform, that is a task which is assigned to him by the principal commissioner of customs or by the board or by the commissioner of customs under Section 5. So Section 5 says that subject to such power and limitation, you see these sections have gone multiple changes over a period of time, particularly after the judgment of the Honorable Supreme Court in the case of Syed Ali. And I'm going to discuss that judgment first, because that is the judgment where the whole story of this officer of customs and the proper officer, the distinction between the proper officer and the officer of customs started. That is a judgment of 2011. And in fact, in this recent review, as I read, not only that judgment of the Canon India has been overruled, but this judgment in the case of Syed Ali, even though that was not part of this review petition, but that has also been overruled by virtue of this review uh, of the Canon India judgment. And in fact, there are several other issues also which have been decided. And if I may point out, so I think I am going to take at least 3 to 4 sessions to discuss the entire issue around this officer of customs, proper officer, power of the DRI and all that. And in this particular review, there are several, you see, aspects which have been analyzed and discussed. And not only you see this review petition of the Canon India has been done, but after Syed Ali, there was an amendment in section 28, and there was a judgment of Delhi High Court, which was also part of this review petition, and the appeal arising out of that Delhi High Court. And there is a so effectively the constitutional validity of section 28, subsection 11, which was introduced subsequent to Syed Ali judgment, that is also part of this review. So I'm not going to discuss everything. Today, I will discuss the very beginning of this story. So as I told you, to start with, first of all, we must understand that every officer of customs who is appointed as officer of customs under section 4 is not necessarily the proper officer to exercise all functions under the law. So some officer may be given investigative function, some officer may be given, so there may be a territorial limit of an officer, there may be pecuniary limit, and there may be a function-wise limit also. So all this is done under the purview of section 5. So in the Syed Ali, which is a judgment reported in Commissioner of Customs versus Syed Ali 2011, volume 265, ELT, page number 17. The issue arose because you see the goods were cleared for import of the goods by the customs authority, and it was found that there is a case of smuggling, and the case was initiated by the officer of customs preventing. So it is the officer of the under the jurisdiction of the collector of customs preventive who questioned that the goods which have been imported are liable for confiscation because there is an evasion of duty, and the goods was seized, and a penalty and the customs duty was demanded. So the case started with that the jurisdiction of the collector of customs preventive, at that time, you see, there was a two different, even today, you see, under section 31, whenever a vessel arrives on any port, then under section 31, the Commissioner of Customs Preventive undertakes an exercise whereby he examines the import general manifest, which is required to be filed by the owner of the vessel to declare the goods which are lying in his vessel, which has come on the dock. And only after and this particular function was assigned at that particular time to Commissioner of Customs Preventive. Once the goods are allowed, so once the vessel, it is declared by Commissioner of Customs Preventive under section 31. that the goods lying in the vessel is matching with the import general manifest, which is filed by the owner of the vessel, then he gives a green signal, which is called entry inwards, and which is the function done by the proper officer who is assigned the function of customs preventive. One may say the customs preventive. Now, after that, the role of the assessment with respect to individual consignment. So it may be that in one vessel, say 100 importers have imported goods. So there has to be obviously separate bill of entries with respect to each consignment. And that each consignment is assessed under section 17. Now section 17 has also undergone substantial change with effect from 8/4/2011, which I will discuss in the next session. Today, I think I will conclude today's discussion with the judgment of Syed Ali, which is the bedrock of the entire dispute emanating. So as I was discussing, the first, under section 31, the Commissioner of Customs Preventive passes an order for entry inward saying that the import general manifest filed by the owner of the vessel is matching with the goods which is there in the vessel. After that, the individual importers can clear their goods on filing of the bill of entry. So individual assessment takes place. Now this happens under section 17. So the entire dispute was that the Commissioner of Customs Preventive is entitled to examine the goods, but he is not entitled to examine the power under section 28, which is a power for the issue of the so-called notice for evasion of any duty. So this judgment says that each officer of custom is necessary. Each proper officer has to be an officer of customs, but each custom officer needs not be a proper officer. Because a proper officer is a officer who is assigned a particular function by the board or the principal commissioner of customs or commissioner of customs. So at that point of time, in this particular case, it was held by the Honorable Supreme Court that even if there is a territorial jurisdiction of the commissioner of customs, collector of customs preventive with respect to the import of the goods, but that particular collector of customs preventive did not, or he was not assigned the function of issuing the so-called notice with respect to evasion of the duty. And Honorable Supreme Court further said that if each and every officer who has the power of assessment and who has the, you see, territorial jurisdiction is presumed to be a proper officer, then it would lead to a situation of utter chaos and confusion, in as much as all the officer of customs in that particular area, whether that particular proper officer. So it was held by the Supreme Court that it is only the officer of custom who is assigned the function of assessment, which it includes the scope of reassessment, working under the jurisdictional collectorate for the purpose of import. That is in whose jurisdiction the bill of entry is assessed and filed and cleared for home consumption will have the jurisdiction to issue notice, and not the officer of customs. So there were two grounds. One is there was no notification under section 28, which empowered the collector of customs preventive to become the proper officer under section 28 of the Act. Further, Honorable Supreme Court went a step further and said that if this is allowed to prevail, then what will happen is that it will lead to a situation of chaos, where all the officer of customs within that particular jurisdiction will become empowered to issue so cause notice, and it will create a chaos. So every officer cannot be given that power, and that function has to be assigned to a particular officer. So on these bedrocks, you see, this Sayyaladi judgment was pronounced. Now, after the pronouncement of this judgment, there was an amendment in the act to correct the lacuna in the act. The act was retrospectively amended to take care of this particular situation where the DRI, where the collector of customs preventive or an officer of the Department of Revenue Intelligence were having no power to issue so cause notice. That defect was tried to be cured by virtue of that retrospective amendment, but all those things I will discuss in the next session. What was the amendment, and by virtue of that amendment, the judgment of the Bombay High Court, the judgment of the Delhi High Court, and the Canon India judgment, review of the Canon India judgment, it may not be possible to do all these things in one go. So as the time permits, so sequentially, I am going to discuss this entire particular aspects. So to summarize the whole issue, the issue is whether a officer of customs, whether a officer of the Department of Revenue Intelligence or a commissioner of customs preventive has the power to issue so cause notice under section 28 if it is discovered that there is an evasion of duty. And this particular issue, it started with Syed Ali, whereby the so cause notice was issued by the Commissioner of Customs Preventive, and it was held by the Honorable Supreme Court that Commissioner of Customs Preventive, even though he may be a customs officer, but since he has not been assigned the function to issue so cause notice under section 28, so he is not a proper officer. He may be officer of customs, but he is not a proper officer to issue the so cause notice, and it is only the proper officer who has been assigned that function to issue so cause notice could have issued the so cause notice. So that so cause notice was struck down on the ground of the lack of jurisdiction, and which led to the amendment in section 28, which led to the judgment of the Delhi High Court, which led to the judgment of Bombay High Court, and which led to the judgment of the Canon India, and which has been subject matter of review of the recent judgment. So I'm going to discuss in the next session. Thank you very much.